We'll get straight off. So Kirsty's going to look at this first question, which is what should we be doing to support people who have been furloughed return to the workplace?
Yeah, thanks, Sue. So now that we've reached the final milestone in the roadmap, this is going to be an issue of relevance for a lot of employers. From work that we've done with clients already who've been through this process as the various restrictions have eased, it's clear that employees can react very differently to returning to work after a period spent on furlough. Particularly, some employees might find it quite difficult to readjust to being back in the workplace. They may feel daunted about going back to work, and they may feel that they've lost some confidence, particularly if they've been out of the workplace for quite a long period of time. Although legally you don't have to give a minimum period of notice to recall people who are on furlough back to work, in practice we would ideally recommend that you give around a week's notice to them, really so those individuals can make any necessary domestic arrangements that they might have. So for example, they may have caring responsibilities or childcare responsibilities, but also because it just gives them that opportunity to prepare themselves and to plan their return to work. When you are thinking about calling people back from furlough, we recommend alerting them before they come back to work about any changes that they're immediately going to encounter when they turn up at the workplace. So, for example, if there have been changes to car parking arrangements or there are new one-way systems for entering the building. As well as those kind of pre-work discussions, another supportive measure that we found has worked quite well in practice for some of our clients is to hold a formal reinduction process when people come back from furlough, ideally on their first day back to work. There's absolutely no right or wrong agenda for what that reinduction process might involve, but as a minimum, we would normally recommend making sure that you welcome people back to the business. You appreciate that it's probably been very difficult for them whilst they've been out of the office on furlough. Importantly, bringing to their attention any health and safety issues, particularly any COVID-related measures that have been put in place. So, for example, what are your rules around social distancing? Are there new entry or exit points? When do masks need to be worn in the workplace, or if at all? It's also familiarising them with any changes that have happened in the business. There may have been changes to rules or procedures, or there may have been significant staffing changes. So again, it's just making them aware of all of those things that have happened. And ideally, if it's possible, we would recommend building in a little bit of time for socialisation, for people to get up to speed with their colleagues, catch up, because it could have been 15 months, a year since they've last seen those individuals. Anybody who has a technical element to their job, you may also need to think a little bit around, do we need to do any training or retraining to make sure that there is no skills loss? For employees who have been furloughed because they were shielding in line with medical advice, those individuals may have their own particular health issues arising from their condition. So again, it's important to think about meeting with those individuals on a one-to-one basis to discuss any potential reasonable adjustments or support with them. And because those discussions are very much likely to be done by, I would say, line managers on the ground rather than via the HR team, I also recommend having a short briefing session with managers in advance of them welcoming staff back to work to give them guidance, practical guidance on how they can support their team and ultimately how they can signpost people to further advice and support. But however long or short that reinduction process is, however it's going to look like, that's going to vary very much depending on the business. But ultimately, having some kind of plan in place will ensure a smooth return, and that's got to be in everybody's best interests. So now I think we're going to pass over to Sue. And Sue, we've had a question. If there are no restrictions in place from the 19th of July, can we get rid of masks and social distancing at work? What obligations will we have after the 19th of July?
Okay, thank you. So regardless of what changes the government have made, employers still have statutory duties to provide a safe place of work, and they've got general legal duties of care towards those who are using or accessing their place of business. And the lifting of restrictions don't change those general duties, although they might affect how you choose to discharge them. So the key steps you should be taking are: number one, carry out suitable and sufficient risk assessments to identify the risks. And you might need to do different risk assessments for certain workers. So for example, pregnant workers, you might need to take extra health and safety measures. Once you've done that risk assessment, you're then going to need to implement all reasonably practicable measures to minimise those risks that you've identified. And the key words here are reasonably practicable measures to minimise the risk. And that's not the same as eliminating the risks altogether. So as of yesterday, there's 6 new sector-specific guides to working safely during coronavirus that have been issued by the government. There's been a lot of talk over the last year about guidance versus law. This is guidance, it's not law, but you should be considering them as, firstly, and obviously, they will help you with formulating your policies and practices. And secondly, from a legal perspective, if you are challenged on whether you have taken all reasonably practicable measures to minimise risk, the extent to which you've considered and followed those guides is almost certainly going to be taken into account. So bearing all of that in mind, that background, can we get rid of social distancing? Well, in the guidance, social distancing requirements have been dropped in favour of measures such as ensuring good ventilation, good cleaning, limiting the number of face-to-face contacts. So we've no longer got a strict requirement to maintain the 2 metre or the 1 metre plus distance, but you might find that in order to implement some of the other guidance, for example, on office layout, it might just naturally result in social distancing. In our experience, many employers, particularly for office-based workers who've been working from home, are reintroducing employees initially on a hybrid, a part-time basis into the office to limit those numbers and enable some form of social distancing to continue. Similarly, in terms of masks, again, no longer required by law, but the new guidance suggests that employers should consider encouraging the continued use, particularly in enclosed and crowded spaces. So some employers might decide to retain masks, either for health and safety reasons in line with their risk assessment, or for business reasons if you think that customers might go elsewhere if you don't retain the masks. If you've got refusals to comply with an instruction to wear masks, it's going to be much easier to defend taking disciplinary action for those refusals if the instruction is based on health and safety grounds. So it comes back to that risk assessment. Another question that came in on the same topic here is, at this time, who should be responsible for purchasing face masks? And I think it makes sense, doesn't it? If you've determined as part of your health and safety risk assessment that employees should continue to wear masks and you're going to make that mandatory, then my view, and it's not set out in law anywhere, but my view is that the employer would be expected to provide those as part of meeting their health and safety obligations, which are legal. Of course, if you're happy with it, then staff will usually be welcome to use their own masks. But if you choose not to mandate the use of masks and leaving it up to individual choice, then my view is that there wouldn't be an obligation to provide masks. So the next question on a different topic, Kirsty, do you think that the furlough scheme will be extended again?
I feel like I need a crystal ball for this question. On the 3rd of March, the furlough scheme was extended up until the end of September, and that was the 5th extension to the original furlough scheme. In my own view, and this is my personal opinion, extending the furlough scheme now seems unlikely, given that we are at stage 4 of this roadmap and the government is very much envisaging a gradual return to work for all employees alongside the successful vaccination programme. I certainly haven't seen anything to suggest that the scheme will be extended further, but given that it has been extended 5 times, even when the government said they weren't extending it, we can't rule anything out. So I think with that one, it's going to be a case of keep watching the space. So now on an extremely hot topic, Sue's going to be answering, can we introduce a no jab, no job policy for both new and existing staff?
Yeah,
Good
I
luck.
got the easy one. So what we're looking at here is whether an employer can make vaccination compulsory for its employees. And it's important, I think, to note that the government guidance doesn't currently provide employers with any guidance or advice on employee vaccination status. So starting with new staff, it's a slightly easier question. There's nothing in law to stop employers from making it a condition of employment drawn into their contracts that employees will be fully vaccinated. Therefore, subject to data protection considerations, which I will mention briefly later, questions on vaccination status could be built into a recruitment process. But whilst having such a policy is likely to be legal, you'll need to be really careful not to discriminate against applicants with protected characteristics. So, for example, while at the moment, my understanding, it might have changed, is that the only publicised recommendation to avoid vaccination on medical grounds is for those who have a serious allergic reaction to any of the ingredients. Some disabled applicants or employees might need to consult with their own doctors and might receive different advice. And in that case, their decision not to get vaccinated might be something arising from their disability. So we'd need to be very careful there. Similarly, ethical vegans might also be protected. We know that the courts have said that that counts as a belief, that is a protected belief. And they might also be protected if they don't want to be vaccinated due to the animal-derived ingredients. Not as likely, but it's also not inconceivable that an anti-vaccination belief could be a protected belief. And that's very much going to depend on the substance of that belief and how it's framed. So the answer is yes, it can be made a requirement of new employment, but we would always advise listening to each and every objection and considering each on its facts to make sure that you're not falling foul of any of the discrimination laws. The position's more difficult with existing employees, as if you have a mandatory no jab, no job policy and an employee refuses to provide you with status information or refuses to be vaccinated, you're going to need to consider what you're going to do about this. Are you going to dismiss? Are you going to discipline? And that's going to be particularly important where that employee has more than 2 years service and therefore, of course, has that unfair dismissal protection. So now we need to consider whether there's a fair reason to dismiss. So looking at what issues you need to consider there, we're going back to that risk assessment that we looked at earlier. Can you show that having the vaccine is the most reasonably practicable way of mitigating the risk of COVID? Is there anything else that would achieve the same in the context of your workplace? If this is the case, then employees could potentially be dismissed for a health and safety breach if you've issued them with instruction. And this is most likely to apply in healthcare settings. So then we need to look at whether there's other valid reasons. So for example, you might have employees who are required to travel abroad regularly. And if there's evidence to show that being vaccinated would avoid some of the limitations around travel, then that might make it a reasonable instruction. It's less clear whether the fact that customer confidence could be improved would on its own be enough to establish a fair dismissal. But you get the gist of the sort of issues that you're going to need to consider to say whether it's going to be fair, whether it's reasonable to make this instruction or whether it's going to be fair to dismiss if someone refuses. Another recent development, which is completely untested and hasn't really been discussed a huge amount, but I think could potentially lead to a fair reason, is the new laws around self-isolation. So at the moment, we're all seeing it. The cases are going sky high. A lot of employers are really struggling as a result of the large number of staff being required to self-isolate. So, as you know, from 16th of August, even if you're identified as a close contact of someone with COVID, unless you test positive, someone who's been double jabbed won't need to self-isolate. So, like I say, entirely untested, but conceivably, I think if an employer can show that its business is severely affected by the need for self-isolation, so businesses where working from home is simply not an option, it's possible that the way in which vaccinations could limit that need to self-isolate will be a factor in how fair a dismissal for refusing to vaccinate is. One final point to note on the fairness of compulsory vaccinations is that the government has announced that vaccination will be compulsory for all English care homes regulated by the CQC. That's going to be enshrined in legislation, meaning that care home employers and potentially agencies supplying to care homes will be able to rely on that legislative basis for dismissing employees who refuse the vaccine. So hopefully a much simpler process for them. If you do have a fair reason for dismissal, you're still going to have to bear in mind, as with new recruits, the potentially discriminatory consequences. So again, the key is going to be open discussions with employees to try to understand why, in each case, the employee isn't being vaccinated. Options short of mandating vaccinations should certainly be considered as well. So there's a big drive over education. Public Health England has shared advice on how employers should encourage vaccination. So we would first recommend promoting the advantages of vaccinations. If that doesn't work, possibly offering incentives. You know, we've heard of employers that are even offering bonuses, gifts to people who are vaccinating, subject always to the discriminatory angle, before finally considering whether, if you really have to, you need to make it mandatory. And I think our next question does address one of those possible incentives. So Kirsty, do we have to allow employees time off during working hours to receive a vaccination?
Thanks, Sue. Unless it's provided for within an employer's workplace policies, there's no general right in law for an employee to take time off for medical appointments. So that's the very easy answer. However, there are very good reasons why an employer may choose to do so in these circumstances. Firstly, employees who are clinically vulnerable may be classed as disabled under the Equality Act, so allowing them time off to go for a vaccination during working hours could be regarded as a reasonable adjustment. As Sue mentioned earlier, employers have this ongoing legal duty to provide a safe place of work and to minimise risks for all employees in the workplace. So arguably, but not tested, this could include enabling vaccination to take place by giving employees time off. But putting aside those really strict legal issues, I think there could be negative PR implications if employers refuse staff time off to attend for a vaccination in working hours when we're still in the middle of a pandemic. So that's certainly something to bear in mind. If you do allow employees time off during working hours to go for a vaccination, that time doesn't have to be paid. So you would be allowed to not pay an employee for the time they spend out of the workplace. But from discussions that we've had with a lot of our clients at the moment, they've very much been taking a pragmatic approach and deciding to continue paying employees to encourage take up of the vaccination. So we're still on the topic of vaccination at the moment, but I'm going to pass back to Sue to ask, how should we deal with disputes between colleagues over vaccination? It can be a really emotional and controversial topic for some.
Yes, I don't know if any of you have had to address this yet, but you can see it becoming a really tricky area for HR professionals in the future. So for instance, there could be situations in which employees are uncomfortable working alongside other colleagues who have decided not to get vaccinated and make their discomfort known. Or employees may spread misinformation about the vaccine and encourage colleagues not to get vaccinated. Where these situations could become especially fraught, I think, is where they involve protected characteristics under the Equality Act. So, for example, if an employee is inappropriately grilled on how their decision about vaccination fits with their beliefs, or if an employee with a vulnerable, disabled child at home accuses colleagues of being irresponsible for not taking up the vaccine. So, as with other issues around clashes of rights in the workplace, this is going to take really careful handling. Should these sorts of discussions be banned entirely? I'm not sure we're there yet. I think that's going to be incredibly difficult to enforce. But employers may need to remind employees just to be sensitive and aware of the diversity of opinion that is likely to exist within the workplace. It's an area that could lead to very risky situations, and I think each one is going to have its own facts. So it's very difficult to provide clear advice on how to deal in general, and you're going to want to seek advice on particular circumstances that arise before taking action. So, Kirsty, what do we do if someone does not want to return to work in the office?
Yeah,
so this workplace.
So this is an incredibly difficult area, and it's one that's cropped up for some employers already as various lockdown restrictions have been eased. Since the 19th of July, generally speaking, now the government is no longer requiring or instructing people to work from home. Employers are going to be in a much stronger position to require employees to come back to the workplace, even if they don't want to do so. But there are issues and risks that need to be considered. The question that we've been asked doesn't actually specify why the individual doesn't want to come back to the workplace, and that really is the crux of the issue. So the first step is going to be opening a dialogue with your employee to try and find out why they don't want to return to work, because that's almost certainly going to affect the approach that you take to managing employees who don't want to return. A concept that didn't really crop up prior to COVID, and to be honest, most employment lawyers weren't even aware the right existed, but there is a statutory right within the Employment Rights Act for employees not to be subjected to any form of detriment, so for example, having disciplinary action taken against them, or to be dismissed in circumstances where they're refusing to come back to the workplace because they have a reasonable belief they are in serious and imminent danger. And for the purposes of that statutory protection, the issue really is whether the employee reasonably and genuinely believes they would be in serious and imminent danger. In situations where this protection kicks in, employees are arguably entitled to stay at home on full pay for as long as they are refusing to come into the workplace because of that imminent danger. Now, the difficulty we're seeing is that protection wasn't designed in this situation. It was designed for extreme health and safety emergencies where an employee has no reasonable option but to take evasive action and leave the workplace. So, for example, if the workplace was burning down and they left work, it really wasn't designed for COVID-19 or this sort of pandemic. So it's difficult to predict at the moment how employment tribunals will apply that protection to the risks from COVID. It's going to be really fact specific. So far as I'm aware, there's only been one case so far which has been reported where an employee has succeeded in this argument, but it was on the particular facts of that case. And a key part of that case is the fact that the employer refused to provide PPE and they refused to put social distancing measures in practice. So when the employee refused to come back to work because he didn't feel it was safe, his dismissal was essentially found to be unfair by an employment tribunal. If an employee does use that reason to explain why they don't want to come back to the workplace, it's going to be really important to investigate their concerns quickly and to provide a very detailed response to limit the risk of that successful claim under that protection. In circumstances, I think, where employers have conducted risk assessments, they've adhered to government guidance, they've put in place necessary health and safety measures, it's going to be much harder for an employee to rely on that provision to avoid returning to work now because of COVID. In other circumstances where an employee isn't ill, they're not vulnerable or citing any specific dangers, but simply doesn't want to come back to the workplace, then potentially you could take disciplinary action against them for failing to follow a reasonable management instruction to return to work. But again, it's got to be provided you're confident that you're taking all reasonably practicable steps to control any of those workplace risks. The alternative approach with those individuals, rather than taking disciplinary action, could be to put them on unpaid leave instead. And we do think that leave can be unpaid because there's the argument that they're not ready, willing, and able to come back into work. If an employee is extremely vulnerable and they are unhappy about coming back to work, dismissing or taking disciplinary action is going to be a lot more risky. That's because many of your vulnerable employees will be disabled for the purposes of the Equality Act. So they have the right to have reasonable adjustments, which could include the right to stay at home rather than return to the workplace. Also, a blanket policy of requiring people to return to work could indirectly discriminate against people with disabilities, which means the employer would need to justify it. And it may be hard to justify requiring an unwilling, vulnerable employee to come back to work if, for example, they could continue working from home or taking a period of unpaid leave. If a vulnerable employee does resist coming back to work on the basis of their health, and partial or full-time home working is not a solution, then depending on the circumstances, and again, it's going to be fact specific, the most cautious approach would be to consider furloughing them if that's still a possibility, or asking them to take a period of leave. There's been a lot of debate and there are a lot of different opinions whether a vulnerable employee who remains at home but can't work from home would be entitled to be paid. And we don't have a definitive answer to that question. However, in my view, and it is just my view, if the workplace is otherwise safe for employees to return, and the only reason that particular employee doesn't want to return is because of their personal circumstances, then arguably I don't think they would have a right to stay at home on full pay. But as with all of these employment law principles, there's definitely not a one-size-fits-all approach to dealing with employees who don't want to return to work. And the usual caveat, take legal advice. So now I'm going to pass back over to Sue, who is going to answer, can we make employees have workplace testing? Are there any data protection issues we need to be aware of?
Thanks, Kirsty. Before I do answer that, we've had lots of people join us since we started. If you have got, at the moment we're dealing with questions that came through to us in advance of today. If you do have additional questions, please do put them in the chat box. A couple have come through. Kirsty, you can have a looking. I think I'm going to be addressing the first question that's there as part of this next answer, actually. But Kirsty, you might want to have a look at the other one. But if anyone's got other questions, please do put them in the chat. And if we have time, we'll try to get to them. So back to workplace testing. So the first point to note is, as of yesterday, the provision of lateral flow tests to businesses is no longer available for free. But individuals will still be able to obtain free tests from the government website until at least the end of August. So employers now need to decide whether to finish their workplace testing scheme, if they already had one, whether to pay for the tests privately, or whether to encourage employees to order test kits directly themselves. Now, in terms of, can you make employees have workplace testing? No, you can't. In the same way as you can't make someone get vaccinated, because it's a relatively invasive procedure and you can't force them to do that. So the real question is whether you can make it a term or condition of their employment or a lawful instruction. And this comes back to considering similar points as we covered earlier for mandatory vaccines. It's less likely that an employee would be able to claim that blanket mandatory testing would be discriminatory. There's few, if any, religious objections and few medical conditions preventing testing that are capable of amounting to a disability. It might also be easier to mandate as the test is arguably less invasive than a vaccination. So if you can properly justify why tests need to be taken, then yes, you could potentially make workplace testing mandatory in the sense that if it's refused, you could take disciplinary action. In terms of who is responsible for paying for these, I'd go with the same approach as for masks. So if you're going to make it mandatory, then the employer should be responsible for providing the tests. And that's the only way to really ensure that it happens in practice. But if it's going to be a voluntary, albeit encouraged programme, then it's up to the employer to decide whether to pay privately or encourage employees to order the tests themselves. As for, are there any data protection issues we need to be aware of? And a question that's come in the chat box, similar, can you ask employees to disclose if and when they were vaccinated for social distancing in the office purposes? So that question, it's all about data protection. So I'm not a data protection expert, so I'm just going to give a very brief overview of the type of issues you need to consider. So before conducting any testing programme, employers are going to need to conduct a data protection impact assessment. And that also applies to the question of whether it's lawful to ask employees if they've been vaccinated or recording their COVID status. And that's because processing employees' health data involves large-scale processing of special category data. So before you decide to check people's COVID status or do workplace testing, you should be really clear about what you're trying to achieve and how asking people for their COVID status or testing is going to help to achieve this. So your reason for checking or recording people's COVID status or doing workplace testing must be clear, necessary, and transparent. This is all the language we hear under data protection law. If you can't specify a use for this information and you're recording it on a just in case basis, or if you can achieve your goal without collecting that data, you're unlikely to be able to justify collecting it in the first place. So it's really a case of, before just putting these things in place, think about, record, make notes of why you're doing it, what other options you've considered. So things like the sector you're operating in, the kind of work your staff do, the health and safety risks in your setting should help you to decide if you have compelling reasons to check people's COVID status or to test. So once you've considered your circumstances, ask yourself these questions. Do I really need this information? Are these steps actually going to help me to provide a safe environment? And could I achieve the same result without collecting personal information, and in particular, without collecting health information? One way around this is if you are collecting status information, you might ask people to bring in their card or show their app showing their vaccination status, and then HR just tick a box. You don't need to actually take a copy of that and record it, because that's probably unnecessary information you're being retained at that point. So it's certainly possible, bearing all that in mind, that employers will be able to rely on health and safety obligations or substantial public interest as the legal basis for processing testing or COVID status data. It's possible, but you need to go through all of those steps first. Now, the ICO has released guidance for employers on carrying out workplace testing, emphasising all of those points and the need to inform staff in an open and transparent manner about the reasons for processing their personal data and what decisions will be made as a result of you as the employer having that information. So it's certainly worth, if you're going to be going down this route, having a look at that guidance before you take action. Okay, moving away from vaccination and testing, and one I know has come up a fair amount with our clients, is how do we deal with employees who have long COVID?
Yeah, absolutely. This is something that we expect a lot of employers are going to face at some point. One of the main issues with long COVID is we don't know exactly how long it's going to last. In a lot of cases, people start to feel better, they come back to work, but then they experience a return of fatigue-like symptoms, meaning they need further time off. There are now growing comparisons between long COVID and ME. when managing somebody with long COVID, the usual rules around sickness absence and sick pay apply when someone's off work. So long COVID shouldn't be treated any differently to any other illness. Once an employee's period of self-isolation is over, they are legally permitted to return to work, so they can come back to work if they feel able to do so. One question that comes up quite regularly is whether we think that long COVID could be capable of amounting to a disability, and there's definitely still some uncertainty around that question. Ultimately, an employment tribunal would have to decide on the specific facts of each case, whether long COVID qualifies as a disability and whether it meets that legal test under the Equality Act. So whether it's a condition that's sufficiently long term and it adversely affects the individual's ability to carry out day-to-day activities. If tribunals do take a similar approach to how they deal with ME, I think employers should assume that anyone who's still suffering from the adverse effects of coronavirus many months after they were first infected are likely, but not definitely, likely to be able to demonstrate that their condition is long-term and therefore a disability. If long COVID does qualify as a disability, there's then a positive duty on employers to consider what, if any, reasonable adjustments can be made to assist that person in the workplace. When managing any cases of long COVID, we would recommend engaging with employees and considering reasonable adjustments, even if we don't think it's a disability. Adjustments such as phased returns to work, adjusted working hours, amending the type of work they're doing, or allowing them to carry on working from home. Another important thing to bear in mind is proactive absence management and making sure that employees are referred to occupational health, or you seek input from the employee's GP at an early stage. Also, there is now an increased link between long COVID and periods of anxiety and depression. So again, highlighting any wellbeing services and psychological support that you can provide to employees is really important. So for example, if you've got an employee assistance programme. Ultimately, with any illness, the level of absence that somebody have could reach the point where it's no longer sustainable. And then it's going to come down to whether an employer can fairly dismiss an employee with long COVID on the grounds of capability. Obviously, that is a very fact-specific question, and it will be really important that an employer can demonstrate that they've done everything they reasonably can do to support an employee with long COVID to remain in the workplace. Currently, we don't have any formal guidelines at all for how businesses should respond or treat long COVID, but ACAS have produced some quite helpful guidance on the topic. And ultimately, the crux of it is to treat long COVID just like you would any other illness. So, Sue, how do we manage an employee who has come back from holiday and now has to quarantine, meaning they can't return to work?
I'll come back to that one, but I've just seen a question from Becky that's relevant to what I was discussing before. So I'm just going to very quickly address that one so we can tick that one off. Becky's asked, can we ask for proof of vaccine status on or after the 16th of August to confirm there is no need for people to isolate if a close contact? I think that's a really good question. It's not one I'd actually thought about, but it's really valid. I think the answer is yes. I think it comes back exactly to those data protection issues. The fact is, you have to self-isolate unless you're double jabbed. That's going to be the law. Employers are going to have a duty to ensure that their employees are complying with that law. So I think you would have very good grounds under the data protection law to ask for that proof in order to allow people in. Caveat to that is, I guess it depends on whether, if they work from home, for example, none of your business really, it's not going to affect you. If they're working in a factory, absolutely. So again, it's going to come back to recording the justification, recording your reasons why you've decided there is that need. And again, ask for the proof of vaccine status. Do you need to get a copy of it, or do you just need to tick a box to confirm that you've seen it? I hope that answers that question.
Mhm.
So now, sorry, back to the previous question. How do we manage an employee who has come back from holiday and now has to quarantine, meaning they can't return to work? Well, the holiday season could introduce new nightmares for HR professionals, as employees may travel abroad and be required to quarantine on return, particularly with the speed at which countries are moving from green to amber to red to back again. So, whilst employers don't normally ask what employees are planning to do with their time off before approving holiday requests, some employers might now consider asking employees to let them know if they plan to travel to a red or amber country so that they can plan accordingly. But if an employee is required to quarantine and self-isolate, you can treat that time in various ways. The employee could work from home as usual, or as they can do. The employee could extend their holiday with the additional time coming out of their overall leave entitlement. They could be required to take unpaid leave, or they could be regarded as having committed a disciplinary offence on the basis that they have knowingly made themselves unavailable for work or risked making themselves unavailable for work. Now, the most common approach last summer was extended holiday or unpaid leave if the employee couldn't work from home. But this year, many employers have needed to make redundancies, and there's more extensive isolation, which is going to make resourcing more challenging, particularly over the school holidays. So we're seeing that treating this as a disciplinary matter is becoming more common, especially where the employer will have costs associated with arranging unexpected cover, agency workers, overtime. So it's going to depend on your circumstances, as with everything, but you can potentially do that. If employees can easily work from home or possibly from their quarantine hotel, it's going to be much more difficult to justify a disciplinary action or withholding pay. But if you're encouraging a return to the workplace from the 19th of July and in-person meetings are essential, that's another factor that could be taken into consideration when you're deciding how to treat those issues. I'm conscious of the time. We have got, I think, one more major question that would be good to cover. Kirsty, do you think? If anyone needs to leave, we've got 2 minutes left. If anyone needs to leave, please do drop off. But otherwise, I am going to ask Kirsty to look at this. How do we go about introducing hybrid working, and what are the pros and cons and risks?
Okay, so this is definitely another hot topic. I'll try and cover as much of it as I can in the time that we haven't got left. Certainly, CIPD research is indicating that after the pandemic is over, the majority of workers would like some form of hybrid working, so working part of the time in the office and part of their time at home. And this has led to this new concept or term of hybrid working. There are definitely pros and cons to implementing hybrid working. I mean, in terms of the positives, I think prior to the pandemic, there was often a lot of suspicion around employees who wanted to work from home and choose their working hours. There was skepticism as to whether it would lead to them doing less work and not being available. But it seems from the pandemic and our experiences that often the opposite is true. Workers get to use their time better, they can avoid commuting at busy times, they can focus on work without the noises and interruptions, particularly of open plan offices. Another, I think, important benefit for businesses, which is often overlooked, is that companies who offer hybrid working can potentially expand their hiring criteria, and they can attract employees from much further afield if there's no requirement for that individual to be physically present in an office or a business in one location 5 days a week. So essentially, it's kind of widening the talent pool, diversifying the workforce, and ensuring that you can hire the best talent. In terms of negatives, I think the main risk with this type of working arrangement is that a culture of overworking can creep into this hybrid working model. remote workers often work longer hours and take shorter breaks than if they were sat in the office. There's always that thought of your laptop sitting on the kitchen table or in your spare bedroom. So often people end up working much longer hours. So in terms of how to implement one of these type of models, the first step as always is going to be doing some sort of consultation exercise or listening exercise with staff. That's going to help you to understand specific preferences and also to identify popular themes about how people would like this to work. As hybrid working is really a form of flexible working, employers can adapt an existing flexible working policy to introduce hybrid working. So it could be a specific category of your flexible working policy, or alternatively, you could introduce a completely separate hybrid working policy. Whichever route you go down as a business, I think it's important to consider what the contractual implications of hybrid working is. So, as you know, most employers are probably familiar with the right to request flexible working under the statutory provisions, and that's a formal request which, if granted, will then lead to a formal change to an employee's terms and conditions of employment. However, with hybrid working, it can be undertaken on a much more informal basis without there needing to be a formal contractual change to somebody's contract. So whichever route you go down, I think it's really important that managers and employees understand the differences between the two and the implications of both. With any new working system and with most employment law practice, the key is to have a clear policy. We would certainly recommend that your workplace policy covers issues such as which roles are going to be eligible for flexible work or hybrid working, because not all roles will be, the process for individuals to ask for hybrid working. Also, from the employer's perspective, you want to build some sort of flexibility into your policy to make it clear that if there is a requirement for an employee to be in the office, so for example, if they're required to undertake training or they need to attend a face-to-face meeting, it's making sure that's built into your policy. And ultimately, having a brilliant, fantastic policy is great, but you need to make sure that it's communicated to staff, because there's no point in having a policy if nobody knows it exists. So apologies that was a really, really quick canter through hybrid working. We could have said so much more on that topic, but I'm conscious that we're over time now. So thank you everybody for joining us for our first Q&A, and also for all of the questions we were sent in advance. They were fantastic. We hope you can join us for our next Q&A, which is on the 6th of October.